Peace and blessings, family. This is your brother G7. If you down with XRP, then you know me. It's Friday, New York, Connecticut time. Okay, in the United States. Listen, I'm ready to go do some yard work and plant some flowers and some vegetables. But before I do that, let me talk to the family. People, family, we know that we've been looking at our phones, we've been looking at our portfolios, we're saying, what the hell is going up with cryptocurrency? If you invest in cryptocurrency, you know, unlike the traditional market that might give you 5%, 10, 15, 20%, XRP can give you 2,000% today and take 1,000% tomorrow. This is how it is. How the hell you think you're going to get rich? You're not going to get rich by having a traditional finance market, money market, instrument that's going to give you 6, 7, 10%. And now when you put your money in the bank, you have negative interest rate. This is the only way you're going to get rich, right? You have to be able to take a chance. But family, with XRP, we're not gambling. XRP, all the financial institutions in the world are going to be running XRP. So family, guess what? I'm going to tell you something. I'm a little selfish, okay? Even though I love the people. But we are selfish because when XRP was 92 cents in December, and then the SEC filed this lawsuit against Ripple, and the price went to 17 cents, family, I was happy. You know why? Because I didn't have enough XRP, and I'm on a fixed income, like a lot of, seniors and a lot of people, right? I couldn't afford to buy XRP if the price went up to $2, $5, $10, $20 then. Okay, so this gives the little guy like me a chance to get more and more and more XRP when the price went down to 17 cents. This is why I was telling people, buy XRP. But family, the reason why they filed this suit is because the fix is in. The fix is in, okay, for Bitcoin, and the fix is in for Ethereum, and they want to destroy XRP. Why do they want to destroy XRP? Family, if you look at it, right, it has everything to do with greed and money and market manipulation, okay? Don't believe me, the OG, okay? I want to direct your attention, right, to Rosalind Layton, right? She writes for Forbes magazine. This came out May 18th, 2021. Now, let me read what she has to say. And family, you're going to know that at the end of what I'm reading, someone is likely, unless Gary Gensler, the new head of the Security Exchange Commission, settles this case, unless he settles this case, someone is going to jail. And they're gonna expose all the dirt that's been going on in the SEC. Okay, someone's going to jail, so they're gonna settle, and it's gonna give a chance, like people like your brother G7 and the rest of us, to get rich. Okay, so this is why the price is manipulated. Okay, because they want to scare us out, but us in the XRP community, we ain't scared. We not yellow. When the price goes down, we buy more. Other people, when the price go down, they sell because they have no idea what the hell is going on. Okay, so now, let me just read this from Forbes magazine. Forbes magazine, that's one of the biggest business magazines in the world. And it says, we need a Ripple test to stop the SEC's overreach on cryptocurrency. Okay, so this is Forbes magazine, May 18th, just a couple of days ago. Now, the regulatory future of cryptocurrency seems destined to be decided by the courts, thanks to an ill-conceived lawsuit filed by the Security Exchange Commission. If Ripple's arguments prevail in the Southern District of New York and on appeal, this case can give the Supreme Court a chance to review the 1946 Howey decision, which set a standard for what constitutes a security. And for this, I just want to take time to say, I want to thank my brother, the Moon Lambo, for bringing this out to my attention. So thank you, brother, Moon Lambo, and everybody give him a subscribe and follow him. He's a good guy, and he does a lot of research, okay, in the XRP community. All right, so Moon Lambo. Okay, so now continue. A courtroom showdown. Now she continues. I've covered the SEC's case against Ripple Lab since it was filed by the SEC in December 2020 because it had all the hallmarks of classic enforcement overreach. Ripple and cryptocurrency investors have fought back robust arguments, while the SEC has stumbled and exposed its former leaders' troubling conflict of interest. It looks like something bigger than the mere lawsuit. You damn right. This is for all the money. This is bigger than a damn lawsuit. The historical moment adds urgency to resolving whether XRP is a currency or security, a question which financial innovation makes difficult, but also demonstrates the SEC's abuse of its power and of its authority. The total market cap of all cryptocurrencies, including the XRP digital tokens at the heart of the Ripple case, tops $2 trillion. Now, it went down for about $500 million because everybody panicked, and you know, Bitcoin is now down to 40,000. Okay, so you know it's a little bit less than $2 trillion. Excuse me, right here. Okay, so now the sum of these digital assets is now worth more than the total number of United States dollars in circulation. Global companies like Goldman Sachs and PayPal are reaching to adopt the technology for consumer products. But more importantly, right, China has already rolled out a central bank digital currency, CBDC, called the digital yuan for domestic, commercial, and consumer use on a big scale. MasterCard has opened talks to act as a financial bridge for China to expand the digital yuan's global network, export its applications and compete against both cryptocurrency as the United States dollar in the emerging digital economy. Okay, they want to compete against both cryptocurrencies. Investors, okay, now check this out. Investors reject the agency designed to protect them. The Security Exchange Commission is supposed to protect us. They ain't protecting us. Those suckers is hurting us. They're trying to ruin us. They're trying to bankrupt us, the average person, right? Now, clearly it's time to re-examine the Howdy tests when it comes to cryptocurrency. Okay, that is already obvious in the pre-trial stage, in which the court seemed to recognize the complexity of building a payment network with distribution of digital currencies like XRP is not always the same thing as starting a company through an IPO. A fatal flaw has already been exposed in one of the SEC's central arguments. The agency insists that all of Ripple's sales of XRP has been one long unregistered security offerings since 2013, and that XRP has never had any utility other than being an investment contract in Ripple. Millions of XRP retail holders around the world, many who have never heard of Ripple, immediately howled in disagreement, apparently to the agency's surprise. Yeah, when I bought XRP, I ain't know nothing about no damn Ripple. I wasn't investing in Ripple. I was investing in XRP. What the hell are they talking about? Okay, so now, okay, Rhode Island attorney John Deaton, and follow him on YouTube. Okay, attorney John Deaton filed a motion to intervene against the SEC's on behalf of thousands of XRP retail holders and dismantle the SEC's argument by detailing case use for XRP unrelated to Ripple. The agency's response was to attack Deaton's character and sweepingly argue that no retail holders should be allowed to intervene as their interests are aptly represented by the defendants in the case. Wait a minute. I thought not Ripple wasn't defending us. I thought it was the Security Exchange Commission to defend us. What the hell is wrong with you? You not defending us? You throwing us underneath the bus and attacking the lawyer's character? Man, these guys are jokers, right? The agency created to defend the interests of retail investors end up categorizing retail XRP holders as adversaries. You supposed to protect us. You said we the damn enemy? What the hell is wrong with you? Oh my goodness. A higher court would likely struggle to conclude that the Howdy test was meant to stretch quite this far. Oh my goodness. In the Ripple case, the SEC is now on trial. Yo, we flipped it. They on trial. Okay? They on trial, and it knows it. SEC stumbles in Ripple case, lost in a maze of its own making, right? SEC versus Ripple, the cryptocurrency trial of the century. Man, they didn't think it was going to go like this here. Now, this gets a little bit more juicy. Check this out. SEC's disregard for due process. Ripple has also raised a basic question of due process. The SEC says it has the right to levy billions of dollars in fines over sales that began 7 years before the case was filed. The problem is that those 7 years have a broad public record of refusal by the SEC to provide any clarity over XRP. For 7 years, we've been asking them, what's up? Work with us. What's going on? Is XRP a security? Is it a currency? And they was like, well, we don't know. Okay. SEC officials made many speeches and interviews in which they made distinct conclusions on the classification of Bitcoin and Ether, but one frustrating vague on XRP. How can Ripple know XRP was a security if the agency itself didn't know until December 2020 when they filed the lawsuit? Worse yet, it's two top executives, Brad Gardenhouse and Chris Lawson, are also named as his defendants, even though Gardenhouse didn't join the company until 2015. What the hell is wrong with these crackers? Therefore, it isn't just the company's due process at stake, but two individuals, raising bigger constitutional implications if the defendant's fair notice defense is permitted in trial. Now this is where it really gets juicy. Check this out. Conflict of interest with former SEC leaders, Clayton and Hinman. Oh my goodness. Oh, this really gets juicy now. Check this out. Finally, there's a nagging question of why exactly Jay Clayton decided to authorize the filing on this case on his final day as SEC chairman. Even the New York Times has raised a series of troubling facts that point to what Deaton called possible corrupt intent. They corrupt, and some of them might go to jail. Okay? Some of them might go to jail. Deaton calls possible corrupt intent. It's a matter of public record that as SEC chair, Clayton said in a market moving interview in 2018 that BTC, Bitcoin, is not a security. Okay, hedge fund one, River Digital Asset Management, bet heavily on Bitcoin days before Clayton advanced the Ripple lawsuit in December 2020. Plummeting the competing XRP and causing exchanges to suspend it. Okay, One River hired Clayton right after he left the SEC. Wait a minute. So Clayton rules against Ripple. One River hires him. I mean, wait a minute. And they representing Bitcoin. I mean, if that's not a damn conflict of interest, what the hell is, right? Okay, the ops are bad enough. But even worse for Clayton's former director of corporation finance, William Hinman. Okay, Deaton has published public disclosure forms that show Hyman collected over $15 million in payments from the Ethereum connected law firm Simpson Thacher over the 4 years while he was at the SEC. Oh my goodness, my man had his hand in the cookie jar. Someone's going to jail. Okay, someone's going to jail if this lawsuit isn't stopped. Okay. Now Hinman's 2018 speech while at the SEC detailed why Ethereum is not a security, sending the token on a rocket ship to its current all-time high price. He left the SEC a few weeks before the Ripple case was filed and quickly rejoined Simpson Thacher, which sits on the Ethereum Enterprise. Which sits on the Ethereum Enterprise Alliance. An online petition to SEC Chairman Gary Gensler by the crypto enthusiasts calling for investigation by the SEC's Inspector General into Clayton and Hyman's possible conflict of interest gained over 30,000 signatures and was submitted. The longer the case goes on, the more attention will be paid to these questions. It's a conflict of interest. They got their money, their hand in the cookie jar, and they're trying to ruin us. Someone should go to jail. The best solution, okay, besides immediate congressional action, with the Biden administration hammering out the regulatory framework, isn't on the agenda. Instead, Gensler has been tasked with a cleanup. If he settles the Ripple case, key questions should still remain unsolved. While Ripple will likely receive relief from the settlement, there's little to stop the SEC from pulling the same stunt again. More largely, some investors want to punish the SEC for its bad behavior and reduce the temptation for it to abuse its authority in the future. In any event, the SEC needs its own Ripple test to restore his credibility. Once again, that's Rosalind Layton. Oh my goodness, family, do you understand what's going on? Okay, let me tell you something. If the SEC doesn't settle this case, someone is going to jail. This is a clear conflict of interest. They were caught. They're caught with their hand in the cookie jar. Today is Friday, the 21st. There's supposed to be a hearing today on evidence, and the SEC has hired 2 top attorneys from Chicago, and their specialty is settlement. They have to settle, okay? They have to settle this case because all the agencies and all the governments in the world are going to start using Ripple and XRP. So family, I just want to wish you guys a nice weekend, okay? And hopefully this brings some little clarity, okay, of what the hell is going on with the SEC's case. We know that it's corruption to the high heavens. Well, I don't know. There ain't no corruption in the high heavens. There's corruption to the low hell. And all they're trying to do is ruin us. But meanwhile, family, buy the dip. The price is low, family. I know this is an XRP station, but I tell you, buy XRP, buy Stellar Luma, buy Cardano, and get yourself some V-Chain. All right, my family? So brothers and sisters, have a good weekend. I hope I didn't stumble too much over my reading. So I'm your brother, G7. Peace. And if you down with XRP, then you know me. Peace, my family.